In this video, we're going to talk about the concept of freedom to operate for patents. Now, in the patent context, freedom to operate refers to the ability to sell one's product or service and not infringe the patent rights of some other party. Let's talk about one important concept first, and it's often misunderstood by entrepreneurs. Having a patent on your product or service does not provide freedom to operate. The two are entirely separate concepts. Let's take a very simple example. Let's say many years ago, you're the first person to invent the concept of putting an eraser on the end of a pencil. Now, pencils exist, but none of the pencils in operation at the time have an eraser device on the opposite end of the writing instrument. You seek and get a United States patent because the concept of having an eraser on the opposite end of a pencil from the writing instrument is novel, non-obvious, useful, and you describe it appropriately and get a United States patent. But some prior person has a patent on having a long wooden instrument with a writing instrument on one tip of it. They have that patent, they've paid the maintenance fees, and it's still in force. Now, while you were able to get a patent on your concept of the eraser on the end of the writing instrument, you can't offer to sell that device without infringing the earlier patent that the person has on the basic concept of a long wooden instrument with a writing tip on it, because you'd be practicing each and every element of that person's claims. So having a patent is valuable, but it doesn't ensure you freedom to operate. Now let's talk about some of the aspects of freedom to operate. The first thing to consider with freedom to operate is when and to what extent should you care about it. One thing people need to realize is that you're never entirely sure about your freedom to operate. There's a couple of reasons for this. First is that you always have blind spots. Recall that patents take 3 to 5 years to issue from the time they're filed. There could be pending at the Patent and Trademark Office an application that if it issues, your product or service will infringe, and it's difficult for you to know about that application. That application may not even be public. Applications don't publish at the Patent and Trademark Office for 18 months after they're filed. So there may not even be a possible way to view this application and know about it. Another reason that freedom to operate is uncertain is that claims in a patent application can change during the course of prosecution. We talked in an earlier video about the amendment process, that an application could be receiving rejections from an examiner, and the applicant could be changing their claims. So you may not know how those claims will ultimately read until that patent issues. Another reason that freedom to operate is uncertain is that there's just a lot of patents out there. Every week, the Patent and Trademark Office is issuing between 3,000 and 6,000 patents. In the last week of December in 2012, the Patent and Trademark Office issued over 6,000 patents. Now, even though not all these patents, in fact the majority of these patents, don't relate to your technology, there's still a lot of issued patents out there, even if you have visibility to those patents, to go through and make sure they don't cover an aspect of your business. So if all these patents out there, and with uncertainty as to what patents could issue that could relate to your product or service, what is reasonable for an entrepreneur to do? Well, most entrepreneurs do have a competitive table. That is a table tracking the competitors and the various features that competitors offer and how those features relate to your value proposition. If you're talking to investors about those competitors, you should also be able to talk to investors about the IP portfolio of those competitors and whether or not they pose a freedom to operate problem for your product or service. So you can at least look at your competitors and look at and understand their patent portfolios and be able to talk intelligently to your investors about your freedom to operate as it relates to your known competitors. Another aspect of freedom to operate is how and where to find these patents that you need to examine. Well, we already discussed looking at patents that are assigned to your competitors. And to do this, you can do a search on the uspto.gov website, the official website for the Patent and Trademark Office in this country, and you can search by the assignee name. So if you know a competitor's company, ABC Inc., you can search and you can generally see if there's published applications or patents that have been assigned to that company. You can also do general Boolean searches on keywords Well, this can be hard because you don't know the exact terms that are being used by applicants. You can also do a search by subject matter, title, and other aspects of a patent application. Now, once you've found a patent that may relate to your product or service, recall that what you need to be concerned about is the claims. It's the claims that define the scope of that other party's patent rights. There may be a title, there may be drawings, there may be a summary that may be very concerning and make it seem like someone has patented a very broad concept that's going to give you a lot of problems. But more times than not, the claims are not as broad as what you think when you view the summary and title of a patent application. So you need to focus on the claims and go through each and every element and see if you offer a product or service that meets each and every element of one of the claims of that patent. And we'll talk about that process a little bit more in a future video. Now, very generally, if you are concerned that a patent claim in another's patent covers a product or service that you offer or intend to offer, you have a couple options. You can seek to design around that patent claim. This refers to changing your product or service, offering it so that you don't meet each and every element of the competitor's claim. And we'll talk about this in a future video. In some cases, it may not be possible to design around someone's patent, but you still deem it worth taking the risk of infringement to go forward, and you can come up with a position that someone else's patent is invalid or unenforceable. In other words, there's prior art or some other defect in the patent, and the Patent and Trademark Office made a mistake in issuing the patent. This is a more difficult position to take because patents that have issued from the Patent and Trademark Office are presumed valid. So the burden, if you were to go to trial to invalidate someone's patent, is higher than the burden you have to show that that patent doesn't cover your product or service. Another option would be to seek taking a license from the company that owns the patent that you think may cover your product or service. So even though that company has a patent and could otherwise exclude you from using, making, selling, offering to sell your product or service in this country, you can go to that company and strike a business arrangement where they give you permission to exercise the rights that they otherwise would have exclusive to themselves by having a United States patent. So this is a very general overview of the concept of freedom to operate in the patent context. We'll cover some of these aspects more specifically in some future videos.